The question is, Michael Woodhouse.
Thank you, Mr. Speaker. I'm very, very pleased to talk in strong support of this bill, and the principal reason is, well, I wrote it, and I want to. As members know, only one bill can go into the ballot, and I do hope that my financial support for live organ donors bill does eventually get pulled. But in the meantime, I pass this on to my very good friend and colleague, Mr. Simpson, who had the great good fortune to have this bill pulled from the ballot. I congratulate him on that good luck, but also on the very careful consideration in the process of bringing this to the House for its first reading, and I congratulate him on the excellent work that he's done. Now, this bill actually had its genesis with a conversation I had with a senior constable in Dunedin who just happened to be my brother. And it's actually quite advantageous coming from a very large family. One gets lots of policy advice on matters like aviation, defence, law and order, resource management, law, education, health and so on. And this was one of those conversations where he described an incident that had occurred to him in Dunedin, not dissimilar to the case that's described in New Zealand Police versus Michael Sidney Childs, described by Scott Simpson in his contribution. Having pulled over a person suspected of drink driving, an evidential breath test was taken where the fellow blew somewhere in the region of 660, clearly over the limit by that measure. He elected blood, but the blood was unable to be taken because he was an intravenous drug user and his veins were not of sufficient quality to draw the necessary blood. Now, suspecting that the driver was also under the influence of illegal substances, interestingly enough, an impairment test under the drug driving laws passed by this government in 2009, and for which I was a member of the Transport and Industrial Relations Committee. Being the new member on that committee, I actually undertook the first impairment test, which was onerous, but nevertheless, this fellow, I passed, yes, having been completely sober at 10:30 in the morning, which is the case, I reassure the House, usually, but in fact this fellow also passed. And therefore, the doors were closed to any form of prosecution under the Transport Act as it exists right now. Now, the judge addressed this issue, and in fact, the police, I think, were quite optimistic in their attempts to charge this fellow both with failing to or refusing to permit a blood specimen, or in the alternative, driving with excess breath alcohol. Now, clearly the latter is not allowed under this bill, and that is what the bill intends to remedy. But he certainly permitted them to have a go, and in fact he challenged them to have a go at getting blood out of this person's veins. And I want to quote the judgment. In fact, I think this quotes the counsel for the defence in the Child case, where he said in a submission that had Parliament considered it appropriate to allow the prosecution to rely on the evidential breath test despite an election for blood taking place, it would have provided for such an occurrence, and that the appropriate place to review circumstances such as the inability to collect a blood sample despite compliance with procedure is Parliament. And that was in July 2012. Well, Parliament, through this Members' Bill, had already addressed it, and this bill was in the ballot. Now, I want to come on to the question of the Attorney-General's opinion in respect of whether or not this actually breaches the Bill of Rights. And I would respectfully suggest that the person writing the opinion on behalf of the Attorney-General is somewhat confused when he or she is describing the effect of the bill would therefore be that the results of some positive evidential breath test that would not otherwise be admissible in evidence would then become admissible. And I think they're confusing the word admissible with the word admitted. The evidence is admissible, and indeed, if blood is not elected, would be valid evidence before a judge. However, the law prevents it from being admitted into evidence, and I think that's a subtle but significant difference. The other part of the opinion of the Attorney-General is that the presumption of innocence does not apply in this case, and I would again respectfully challenge that the defendant, with whatever evidence is presented before the judge or jury, is presumed innocent in just the same way that had blood not been elected, the breath evidence would be admissible, the presumption of innocence would prevail. However, I do accept that this is an issue for the Select Committee to deal with when it comes before it, and I hope that it does. And I'm sure the Transport Committee under David Bennett will look at that issue very, very closely. Mr. Speaker, I strongly support this bill. Good speech.
Charles Chevelle.
Thank you, Mr. Speaker. Mr. Speaker, I think the previous